Ladies and gentlemen, well, we'll see if this works. Okay. Ladies and gentlemen, you are considering the case of the State of Georgia versus Trinity Poague. The grand jury has indicted the defendant with the offenses of malice murder, felony murder 2 counts, aggravated battery 2 counts, and cruelty to children in the first degree. I have previously read the indictment to you, and you will have a copy of it with you in the jury. Well, you have the original with you in the jury room. The defendant has entered her plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered by you as evidence. It is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law that I give you in this charge to the facts as you find them to be. The defendant is presumed innocent, presumed to be innocent until proven guilty. The defendant enters upon the trial of this case with a presumption of innocence in her favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offenses charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you will be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. And facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Your oath requires that you will decide this case based upon the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial, stipulations of the attorneys, that is, any facts to which the attorneys have agreed with approval by the court, and any matters of which the court has taken judicial notice. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks by the attorneys, or questions asked by the attorneys. Where the parties stipulate testimony, documents, exhibits only, this is the nature of evidence. You may take that testimony as if it were given in court, and you may rely on it if you find it credible. However, either party may dispute such testimony by other evidence. You make all decisions based on the evidence of this case. And by the way, you will have this jury charge, or this written charge with you in the jury room, along with the indictment, your verdict form, and all of the evidence that was admitted as exhibits, other than the videos. The videos will be in the courtroom. Direct evidence is that which may be seen or heard or otherwise directly sensed, such as by smell or taste or touch. It may be brought into court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence by inference points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial or indirect evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in the light of your experience. It is evidence that only tends to establish a a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence. Whether dependent upon direct evidence or circumstantial evidence or both, the true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, then you must acquit. If so, you may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for the jury, to decide. Similarly, the jury must decide the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witness's manner in testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility insofar as you are able to observe it. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. Testimony has been given to you in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. You would evaluate such testimony as you would that of any other witness. However, the defendant does not have to testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. The defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be in your discretion inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. The law provides that criminal actions shall be tried in the county in which the crime was committed. Venue, that is, the crime was committed in Sumter County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offenses. Venue must be proved by direct or circumstantial evidence or both. Now, this indictment has several counts. You will need to consider these instructions and the facts of the case and reach a separate and independent verdict with regard to each count. Count 1 of the indictment charges the defendant with malice murder. For malice murder, the state must prove that the defendant caused the death of another person unlawfully and with malice aforethought. That the killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification. You may find malice when the circumstances show that the defendant acted with the deliberate intent to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, then that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proven by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. Counts 2 and 3 of the indictment charge the defendant with the offenses of felony murder. The state does not have to prove, for felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated battery and cruelty to children in the first degree are felony offenses, which I will define for you shortly. You may find the defendant guilty of felony murder, as alleged in counts 2 and 3 of the indictment, if you believe that she caused the death of another person by committing the felony of aggravated battery, as alleged in count 2, or by committing the offense of cruelty to a child in the first degree, as alleged in count 3, regardless of whether she intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. Count 4 and 5 charge the defendant with aggravated battery. For aggravated battery, the state must prove the defendant maliciously caused bodily harm to another person by depriving that person of a part of his or her body, by rendering a part of that person's body useless, or by seriously disfiguring a part of that person's body. For cruelty to child in the first degree, which is the charge in count 6 of the indictment, the state must prove that the defendant maliciously caused cruel or excessive physical or mental pain to a child under the age of 18. In deciding whether the defendant acted maliciously with regard to cruelty to a child, understand that malice is not ill will or hatred. Malice in this context means an intent to cause the pain without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the pain may result. Now, by no ruling or comment that the court has made during the progress of this trial has this court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given to you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, economic status for or against either party. You are only concerned with whether the defendant is guilty or not guilty. You are not to concern yourselves with punishment. One of the first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind, talk with each other, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. I'll remind you, you're not to have phones in the jury room. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Now, as I mentioned, this indictment involves multiple counts. You should consider these instructions in reaching your verdict with regard to each count independently and separately. And we have provided you a verdict form with regard to that will allow you to express your verdict with regard to each count. So using the verdict form, for example, with regard to count 1, for example, of the indictment charging the defendant with malice murder, if after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Sumter County, Georgia, did on or about January 14, 2024, commit the offense in count 1 of the indictment, you will be authorized to find the defendant guilty of the offense, in which event, with regard to count 1, the form of your verdict would be, we, the jury, find the defendant, and you would check or X guilty. And then, on the other hand, if with regard to count 1, you do not believe that the defendant is guilty of the offense of malice murder, as charged in count 1 of the indictment, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict with regard to count 1 would be, we, the jury, find the defendant not guilty, and you would, under count 1, X not guilty, or check not guilty. Again, you should independently and separately make such a determination with regard to each count of the indictment. Whatever your verdict is, it must be unanimous, that is, agreed to by all 12 of you. The verdict must be in writing and signed by one of your members as foreperson, dated and returned to be published in open court. Now, in just a few moments, I'm going to ask you to retire to the jury room. But again, do not begin your deliberations until you receive the indictment, the verdict form, and a written copy of these instructions and the evidence that will be presented to you in the jury room. As I mentioned, what I want you to do is once that happens, select your foreperson and either begin your deliberations, or you can start your deliberations, and if you want to take a lunch break, let me know. If you want to start your deliberations and have us order some pizza and bring it into you, we can do that because it's right around lunchtime. But I don't want you to rush. If you'd rather go to lunch and come back, that's fine. If you would rather have lunch as you deliberate, that's also fine. Whoever the foreperson is needs to make sure that the jury is not deliberating unless all 12 of you are in the jury room. So, in other words, if somebody steps into the restroom, you should suspend your deliberations. Okay? Or if you take a break, you should suspend your deliberations. With that, I'm going to allow you to retire to the jury room, and once you get the evidence, the verdict form, the indictment, and the instructions, you can elect a foreperson and begin your deliberations. Wait, we have 3 alternates. If you wait just 1 second. I've got it. Jacob Cromer, Johnny Lassiter, and Sadie Golden. You three are alternates, and we're going to sequester you separately. But all of the instructions I've given you about discussing cases and things of that nature apply. Y'all are not yet able to discuss the case or do any research or anything of that nature, even with each other, unless you're brought into the jury room. But I do need you to remain in the courtroom. We have a different room. Judge Rambo has a state court office over here, and y'all will stay in there and just remain available. Everybody else can retire to the jury room. All right, if y'all come up and make sure all the exhibits that are going back are ready. Mr. Lamb, if you. Well, first is there. Chet, if you'll grab that door, please. Is there any exception to the charge from the state, from the defendant?
No, Your Honor.
Okay, that'll be fine. Malice, if you'll help them gather and organize the exhibits to go out.
I don't think I put it anywhere. Stephen, are my exhibits all in? Are they? I mean, would they? Do I have any missing numbers, or should I have every number?
All right, we're off the record.
You should have every number.
Except for like the